All right, ladies and gentlemen, let's move on to chapter 7, where we will be talking about judges. As an introduction, judges are public officers authorized by law to hear legal disputes, administer the law, and preside over courts of justice. This technical definition, although accurate, does not begin to convey the importance of the position or the varied roles and duties placed on members of the judiciary, and that's what we call judges, the judiciary. Um, the decisions judges make and the manner in which they are made affect individual lives and also how the justice system is perceived throughout the country and across the nation, if not the world. So judges are essentially like the poster children or the figureheads of the criminal justice system. When you think of justice and who's making the outward decisions of guilt and innocence, or not necessarily always guilt and innocence, but they're definitely sentencing people because a lot of things happen in court, people get convicted, but it doesn't really hit home until a person is sentenced and they go to jail, and the judge is the person that does that. They judges tend to be that outward representative of the criminal justice system. So what they do is very important, and the roles they play and how they do it is very important, which we'll talk about earlier. Later. I'm sorry. Roles and duties of judges. Judges are viewed as the most powerful and important actor in the criminal justice system. Beyond these symbols of deference, however, the power and actions of trial court judges are greatly limited by the criminal court system structure, procedures, and other actors. What that means is they have power, but their power is limited because of other actors. There are a lot of things that defense attorneys and district and prosecutors can do, and they're working back and forth to take discretion away from judges. So we call it, if as a defense attorney, if I have a plea deal arranged um, with a DA, and that plea deal within the deal itself, we call them scripted deals. That means that the punishment itself is written within the deal. So the punishment that my client's going to receive is already agreed upon. So if we have a scripted deal, and we take it in front of the judge and we enter the plea deal, the judge has only two options: either accept or deny what we put down. But they can't change it because that's the work product. That is the contract that opposing sides have signed. So there's not really discretion for the judge in that situation because the other two parties have intervened and kind of done it. The judge is just the last person to kind of make it happen at the end, or finalize and put the judgment into action. So let's see here. Trial court judges are active participants at multiple stages of the criminal justice system's processes. And this would be from before the suspect is arrested until after a convicted defendant has completed serving a prison sentence. So we're going to kind of go through the roles they play from the beginning. That would be pre-arrest all the way through the end. So pre-arrest judicial roles. Search and arrest warrants must be signed by a judicial official. So even in the infancy stage of a case, let's say a crime has taken place or is accused of taking place, so now law enforcement has to investigate that crime. In the investigation of the crime, and this is before anyone is even arrested, the law enforcement officers have to depend upon judges to when they get ready to get warrants for arrest or definitely or search warrants. So if they have a suspect or someone in mind and they want to search their home for the contraband or the murder weapon, sorry, or some evidence, then they have to get a warrant signed by a judge. So a judge at that juncture is a very important person because as we'll learn later in the based upon the Fourth Amendment, if they don't get that warrant, then they are more than likely the evidence that they get from whatever search is likely to be excluded from trial. So if law enforcement is there to investigate, figure out who committed a crime, and hopefully get a conviction of that person that they believe to committed a crime, then they're going to make sure they want to do it right so they don't lose the evidence based upon the technicality. So they want to make sure they're within the Fourth Amendment. So that means they're going to have to go to a judge and explain probable cause. So the first person, even this is before a person is even arrested, just this is in the investigatorial portion, a part of the criminal process. Law enforcement officers need judges. There's a place and there's a role that judges play in that, and even in that part. And of course, judges are not just rubber stamping these warrants, arrest and search warrants. Judges have an obligation to review each application for a warrant to determine if it provides probable cause to justify the requested search or arrest. They must ensure that the place to be searched is clearly articulated and that the items or class of items sought are stated and described with sufficient specificity. The judge may be asked to allow police to conduct the search at nighttime or enter the place to be searched without knocking on the door, whether requesting entry or announcing their presence. So all that stuff is decided upon. Of course, the judge has to sign a warrant, and that's pre-trial. Now, or not pre-trial, pre-arrest. So now let's talk about post-arrest / pre-trial roles. Following the arrest of a suspect, the focus of the criminal justice system moves from the law enforcement arena, in other words, what law enforcement is doing, and whether or not what they're doing is constitutional. Now it shifts to the court system. So now this person has been arrested. Now it's all about what the court system is doing to ensure the rights of this newly arrested person or arrested and charged person. A person placed under arrest and held in custody must be brought before a judge for an initial appearance within a reasonable time period. This is generally 2 to 3 days after arrest. At the initial appearance, the judge informs the defendant of the nature of the charges associated with the arrest. The judge must determine the conditions imposed upon the arrestee to be released from custody. So, what are going to be the conditions of the arrestee's release? Of course, it's not meant setting the conditions of release is not meant to be punitive, but meant to ensure the defendant's reappearance at further court proceedings, as well as conditions that may be necessary to protect the safety of individuals or community at large. And an example would be posting bond or bail, setting a bond or bail so that they pay money, and of course that's collateral. Once they finish the case out, no matter how it ends, then the defendant is entitled to get that money back that they paid. So it'll come back to them. Especially now, of course, that's with secure bonds. A little tired today, but that's with secure bonds. We talk about bonds later, but that's just an example of the function of judges. Let me see. So post and bail bond. Sometimes they set behavioral requirements during pre-trial release. Of course, they can order you not to contact anyone, not to associate anyone, specifically the victim sometimes, and other times co-defendants that you are alleged to have committed a crime with. And also they can force you not to leave the state or the jurisdiction you're in. And this is all pre-trial. Judges must balance the need for public safety and administration of justice against the right of a defendant who is presumed innocent. So we want to get to the bottom of justice, but we want to also make sure that what we do is just, and that the person that is accused is in fact innocent. Prior to trial, judges also frequently do what they can to encourage a plea agreement to be reached between the parties. Judges like plea agreements because they keep the court from being backlogged and keep the trial backlog low. So to avoid, of course, this is to avoid time and cost of trials. Judges may also imply that there will be informal sanctions if a plea deal isn't reached. And examples of that would be adverse rulings on procedural motions or increased sentence for defendant if convicted after demanding a trial. So stuff like that. Um, Judicial roles at trial. The most visible role played by trial court judges is providing presiding over jury trials. Sorry about that. Of course, in this capacity, the judges make rulings on the admissibility of evidence and objections. So that's a very important part. When you have a judge that is just serving as judge and it's not a bench trial, the judge does not control the verdict, but the judge does control what evidence gets in and gets out based upon the rules of evidence, which is very important. Judges instruct the jurors on the law. They instruct jurors on the law they're applying in reaching a verdict. I'm sorry. Following the presentation of the prosecution, the defense cases, the judge has the duty to consider whether there has been sufficient evidence presented for a jury to find that the defendant is guilty of each charge beyond a reasonable doubt. If the judge does not believe this, the judge should direct a verdict or acquittal for the defendant before trial or before jury deliberations begin. Should the jury convict the defendant, the judge retains the ability to then enter a direct verdict of not guilty if she believes there is not sufficient evidence to support a conviction. So what that means is even if a person's convicted, the judge has the ability to say, well, the jury got it wrong, because jurors don't know the technical things. They just know there's evidence there, but they may not know that the evidence links this person beyond a reasonable doubt to the crime. In certain situations, the evidence isn't very good. And in those situations, before the jury can come back with a verdict, the judge enters a verdict. And that's what we talk about. Let me see. Yeah, that's what we talk about in discretion of judges. Also, they are responsible, judges are, for seeing that the proceedings are conducted in a way that upholds the dignity of the proceedings and the appearance of fairness in the eyes of the public. What are the judicial roles post-trial? This is after trial, where they be specifically doing conviction. If you're convicted. Following a conviction, whether by plea or trial, it is the judge's duty to impose a sentence. The sentence a judge imposes is limited to what is permissible under the statute on which the conviction is based. All right. So you have different types of sentences that different types of sentencing that a judge can give out in punishing. You have determinate sentencing. In this situation, there's discretion of the judge in regarding sentence length is restricted to a range of time. So that means between this time and this time, as a defendant, when you're getting out of jail. Intermediate sentencing. A judge may have wide discretion in determining sentence length. Then when judges sentence defendants to prison, they have a great deal of. When judges sentence defendants to probation, judges have a great deal of discretion in deciding what conditions of probation a defendant must abide by to avoid incarceration. This may be, regular alcohol, drug testing, substance abuse treatment, counseling, education, employment, fines and restitution, limits on places the defendant may go or people that they may associate with. Of course, in indeterminate sentencing, and I meant to go back to that. That's why I was mixed up. Judges have a wide discretion in determining sentence length. So, in determinate sentencing, there's usually a exact day, or there's an exact range of days. So either this amount of time as a minimum and a max. With indeterminate sentencing, it's a wider range. So you're going to get between 8 and 10 months. 8 months is a minimum, 10 months is a maximum, and somewhere between there you'll get out. That's indeterminate sentencing. Involvement of a trial court judge is not necessarily over once a sentence has been imposed. And that an example would be the judge may preside over probation violation hearing. So once a person is put on probation post-conviction, so we've already gone through the trial, the defendant has been convicted and sentenced, and the active sentence is suspended and they're placed on probation. Once they're on probation, as I said before, the judge can place them on probation and say, in return for not going to jail or being on probation, you got to do this, and this. They'll give them a list. You must not take any alcohol or substance abuse. Narcotics. So that means you're going to be subject to urinary analysis. You can't be with this person. You got to have a curfew or something like that. And they give them a time limit. If within that time limit they fail to do something, their probation officer can always come back to court and file a violation against them, in which they got to come back to court and answer as to why they didn't do what they were supposed to do. So, last but not least, you have administrative duties. In most jurisdictions, individual judges manage their own courtroom and support staff. This management may involve allocation of duties, job performance evaluations, and personality conflicts. Judges have the freedom and responsibility to set their court schedules. Scheduling can be difficult due to case backlog. So that's the number one enemy of things moving through the court system fast, and that is what we call case backlog. So there's so many cases stacked on to each other, waiting to be tried, that the system kind of never gets to it. It creates a backlog, and even as fast as the system moves, it is what it is. That's how fast the system is moving. Okay, as said before, judges have the freedom and responsibility to set their court schedules. As I said before, okay. Judicial selection, how are judges selected? At the start of the different judicial selection methods, or at the heart of the different judicial selection methods, are the concepts of judicial independence and judicial accountability. What's that mean? Judicial independence is the freedom for the judge to make decisions without having outside influence. So I'll read your book's definition. Let's see. Okay. An independent judiciary is one that can make decisions without interference from the other branches of government or concern for the popularity of political consequences. That's essentially what judicial independence means. They can make their judgments and render verdicts or sentence people and not worry about what the outside is doing, because they had strict statutory guidelines and they sentenced them in that. So, independence is very important. So that means there's no outside influence that's making them now choose not to enter this plea that may be just, or enter this conviction that may be just. Judicial accountability involves the ability of society or the government to observe the performance of judges and remove from office those who are performing below standards. So it's always a balancing test between judicial independency and judicial accountability. So accountability is primary what you act like. So act like you got some sense and judge right. In other words, if daddy's supposed to get the land, as a judge, you should know the law and apply it well. Um, let's see. All right. Judicial independence and accountability are both equally important. They are. You need account. Well, you need independence. You need sometimes uh, judges to be able to make their decisions, even if they're novel or new decisions, to be able to make them with confidence, not knowing that someone's breathing down their neck right now. And they also need to make sure they're accountable for their actions, that they take safety precautions or whatever they do, that they pay attention to what happens to people that have accidents. Sometimes they die. So of course that leaves them open for lawsuits. So um, yeah, of course, with judicial accountability, it involves the society or government to observe the performance of judges and remove from office those who are performing low. So, of course, if you perform low, you'll get removed. But it allows the people to kind of speak. So you want to have a good, what would I say, um, kind of mix between judicial independence and judicial accountability. You want to be free to make these decisions, but you also want to be accountable if you go out of pocket and do something way wrong. Let me see. So that's why they're both equally important. Federal judicial selection. So we're going to talk about federal judicial selection first. A lifetime appointments from the presidential appointments ensure that judges will be independent of other branches and not beholden to them to maintain their judgeships. So that means on the federal level, once you become a judge, unless you're impeached for committing some high crime or misdemeanor, then you're going to stay there forever until you die. So you don't leave. You're a judge for the rest of your life unless you want to retire or resign or something like that. But I don't know many judges that do. Uh, when federal when a federal judicial vacancy arises, the president's staff and officials at the Justice Department search for local candidates from the state or circuit where the vacancy is located. Input is obtained from party leaders, prominent attorneys, and judges and campaign supporters. So they kind of get to take the show on the road to kind of advocate to the president why this person should be there or be in the judgeship. Then you have senatorial courtesy, the process whereby the president defers to the wishes of a senator from the state where a vacancy is located, and nominating the person for district court. I'm sorry, and nominating the person for district court judgeship. So that's how that goes. So the senators they kind of get to have a little bit of input because the senators serve a specific state within the jurisdiction. So it's always good to get input from someone that has boots on the ground or is connected to that district. Let me see. Senate Judiciary Committee. The Senate Judiciary Committee sends the nominee questionnaires about his or her background and writings, which are scrutinized by the committee. The nominee may be asked to appear at hearings where he or she is questioned by members of the committee. Following testimony and considering other information collected on the nominee, the committee makes a recommendation for the full state, which votes whether to which the full. See, getting lost here. I'm sorry, y'all. Talk about background. They may be asked to appear at hearings where they are questioned by members of the committee, following testimony, considering other information collected on the nominee. The committee makes a recommendation for the full Senate, which votes to confirm or reject the opponent. The appointment. Federal judges can only be removed by impeachment for treason, and as we talked about before, treason, bribery, and other high crimes or misdemeanors. If impeached, a judge is tried by the Senate. To remove the judge, 2/3 of the Senate must vote to convict. Proponents of appointments say that it provides for judicial independence, and the process results in better vetted judges. If you think about it, how many organizations have to vet and figure out who this person is and know who they are, and that they're going to be a sound judge. Gubernatorial appointment is subject to approval for legislation in some jurisdictions. Gubernatorial means the governor appoints in that state. Partisan election, the most commonly used form of judicial selection, where the judges are selected in a popular balloted election based on political parties by the citizens of that jurisdiction. That means a judge runs for office as a Democrat or Republican or whatever party they're from, and then it goes that way. So people can vote straight party ticket and choose a person, or go in and choose that person. Then you have nonpartisan elections. That's what we do here in North Carolina. The most commonly used form of judicial education, where the judges are selected in a popular balloted election by the members of that jurisdiction, where the principal party of the candidates is not divulged. Principal political party of the candidates is not divulged on the ballot. So you don't know what political party they're in. You just know they're there. Now, a lot of times, especially in a place like Greensboro, people know, the judge is a Dem or judge is a Republican. They kind of know that and know where you stand. Diversity on the bench, the effect of the selection system on who becomes a judge. So hold on, let me see, make sure I got everything. We talked about partisan, so nonpartisan election. Then last but not least, we have the merit system, what we call the Missouri Plan. It's a form of judicial selection where a nonpartisan nominating committee selects a list of potential candidates based on qualifications. The governor makes a selection from the list, and the selected judge stands for retention election within a short time after being elected and serving. So they got to vote, truly a vote of confidence they have to have. Judicial socialization and development. Very little specific training for the job. There's very little specific training for the job of being a judge. There are no classes in law school to teach how to be a judge. Got a call coming in. Call it later. Sorry about that. I'm in my office. New judges were most likely successful attorneys who possess sharp legal skills. So that means they go into being judge kind of knowing a little bit. Of course, needing more direction, but they at least have a good starting point. People calling me. Excellent legal ability is just one of the many qualities we expect from judges. New judges face a period of rapid adjustment that is frequently a rude awakening. That being that a judge might not expect might not get what exactly what it was expected. So, in other words, being a judge is not exactly what the candidate expected. Because once you get in that seat, it's different. It must be different. There are, however, learning resources, but it's not. It's mostly on-the-job training. Judges normally specialize in very few practice. Attorneys normally specialize in very few practice areas, but as judges, there is an expectation that you will preside in trials outside of your practice specialization. I'm a criminal attorney. If I ever become a judge, they may put me in civil court or divorce court. I have to catch up to that stuff. I can, and they're going to give me time, but you go to judicial classes and training to kind of step that up. Judicial accountability and judicial independence. Judicial accountability, the ability to of an entity to remove or discipline judges who do not perform their jobs in an acceptable manner. Let me see. Okay. Um, a level of judicial accountability is expected, uh, but it is important that the that it not interfere with judicial independence. Let me see. Judicial independence is ensuring that judges are free to decide cases fairly and impartially based on the facts and the law without considering of the public mistrust or public situation they may encounter. Um, then you have decision accountability. It holds judges answerable for for judicial rulings where the judge deliberately ignores the stated law and binding precedent. The judge should be held accountable. Okay, behavioral accountability is when you hold individual judges answerable for their conduct on the bench, conduct which reflects badly on the integrity and impartiality of the justice system and is likely to and decrease public trust in the judiciary and should be deterred. Performance evaluations. In general, voters have very little information about judicial candidates. If anyone's ever voted, you realize there may be candidates for a judgeship, but you're like, I don't know that person. So, of course, not knowing leads to level of fall off. So, there are people that don't mind actively participating in voting, but it's like, who do I choose from? If I don't know them, I don't want to vote. So that leads to fall off. So and there's people not voting. These judicial performance evaluations system keys or keys to their systems. What they use. It involves information only from individuals who have firsthand knowledge through observation of a judge's performance. Uh, to expand the sources of information about attorneys to include laypersons, jurors, witnesses, and court staff who have had the ability and personality to observe the court's performance. The information is then processed to the public, considering condensed form to use as a condition in now to vote elections. I'm sorry, reading that wrong. Sorry, I got writing's real light. This information is then provided to the public and condensed in a condensed form for use in considering how to vote in elections. So when they get information out, and of course they're produced by judicial performance evaluation, where they take polls, they talk to people that work with the judge every day, and they get the outcome of that poll to everyone in the community, so the community, even though they've never encountered this judge, can figure out who he is and whether or not they want to vote for him. Accountability for judicial misconduct. And impeachment, of course, is federal, only where there's an allegation of treason, bribery, or other high crimes or misdemeanors. Judicial councils reform and the Judicial Conduct and Disabilities Act of 1980. 1980. It says that let me see. Procedures were laid out for filing a complaint against a judge, and means are provided for disciplining the judge if the council treats it differently. So you're a public servant as a judge, not necessarily on the highest of high pedestals. The council may also refer to the House of Representatives with a recommendation that impeachment proceedings be commenced. Each of the 50 states has organizations established to investigate allegations of misconduct by state court judges. Judicial disciplinary commissions created by the state Supreme Court, and they're generally made up of a combination of judges, attorneys, non-attorney citizens, and they're tasked with investigating allegations of misconduct. If complaints do have merit, the commission may recommend the imposition of discipline against the state. An example is a peach, or what do you call it? Public or private censure. You have suspension or removal from the bench. So there's a lot that can happen. It's pretty embarrassing if you've reached the plateau of your career and being a judge, and now your name is published in the book as someone that got censured. And it's essentially saying what you did and everything. Suspension is one of those situations too, where you suspend the case or whatever. You got to stay on top of it, or the removal from both, or removal from the bench. I'm sorry. State Supreme Court makes the final decision based upon these recommendations. Okay, so that's chapter 7. I hope you understood. I know I was jumping around a little bit and unclear. Ink kind of crazy. It's kind of crazy in my printer, so it's hard to really read. I didn't want to make a lot of mistakes. But you guys be good. That's chapter 7. If you have any questions, give me a call or give me or email me. Take care.